Okay. All right. Good afternoon, everyone. It is March the 12th, 2025 at 2:06 p.m. And this is another meeting of the Public Safety Subcommittee for the House Judiciary Committee. We have four bills that are in front of us this afternoon. House Bill 154, House Bill 164, House Bill 202, and House Bill 560. Committee, what I was thinking about was discussing this bill sort of as a group. If you remember, we sort of had an initial conversation about all four of these bills, I think at one time, kind of earlier in this session. And if you remember from our bill hearings, all four of these bills really deal with or are trying to address the exact same issue, which is colloquially known as squatting. And so I've had a couple conversations with the various bill sponsors in an effort to try to see if we can come to some type of compromise with regards to really the issue that all four of these bills are seeking to address. And you should have received in your inbox a proposed amendment, which hopefully will kind of address the concerns that these bills are trying to address, which is situations where individuals are unlawfully occupying a property, whether it is a situation where the property is vacant and someone just decides to move into the vacant property of their own volition because they're unhoused and looking for a place to stay, but does not have rights from the owner to occupy that property, or a situation where you have a tenant that's holding over, or whatever the case might be. And so, really, the mechanism that we have currently in the law is really the wrongful detainer statute as part of the real property article. And so, what you see before you is a proposed amendment to amend the wrongful detainer statute, which is the mechanism that most people would have to go through today in order to remove someone who is unlawfully in possession of their real property. And what the amendment proposes is to reduce the time frame that it would take for someone to really get a court date and an order through the wrongful detainer process. And so I have the amendment up. Hopefully, everyone has it. And you'll see in the amendment what it does. It basically requires the court to schedule a hearing after the wrongful detainer complaint has been filed, not less than 4 calendar days, but not more than 7 calendar days after the complaint has been filed. So hopefully, with the filing of the complaint, the person would have a court hearing within 7 days from that date. And they do have to attempt personal service, because I think one of the feedback that we had heard during all of these bill hearings was concerned about service and due process and making sure that the defendants in these cases are being properly served. And so this does also provide for a mechanism of they would have to attempt personal service at least twice on two different days. And then if they're not able to attempt personal service, they can obtain what we call alternate service, meaning they would have to mail the summons and complaint via first class mail as well as certified mail to the person who is allegedly unlawfully possessing the property, and affix the summons and complaint on the property in a conspicuous place on the property there. Um, and so that would be deemed good service under this statute, under that provision. They would have their day in court. And then at that point, if the judge finds that the person is unlawfully in possession of the property, the court would issue an order that would then allow the sheriff to go and deliver possession of the property to the person who filed the complaint. Um, so I don't, oh, Claire, I see Claire is here, our counsel is here. I don't know if I missed anything in that description of the amendment, Claire, but please, if there's anything I'm missing, please do correct me.
No, that's everything.
Okay. And so I did, like I said, I did speak with Delegate Holmes, Delegate Naraki, and Delegate Conway about about these changes. So we are putting this language all into one bill. They are all willing to sign on to the bill, and so you'll see their names all listed there at the top, along with Delegate Alston's bill, which was not referred to the subcommittee. But if you recall, I mean, not Delegate Alston, Delegate Addison. But if you recall, Delegate Addison also had similar legislation as well to address this problem. And you will see that they're listed there at the top. So I'm happy to answer any questions. Yes, Delegate Schmidt.
Thank you, Chair. Delegate Austin's bill is 254.
Is it 254? I mean, Delegate Addison's bill?
Addison's bill,
It's
sorry.
Yeah,
271. I thought it was 271.
yeah, I thought it was 271 as
All right,
well.
so 154 is Conway.
164 is Conway.
No, 154.
Yeah, Conway has two bills. So 154 and 164.
164. Okay.
And then Delegate Naraki has House Bill 202. And then Delegate Holmes had House Bill 560. And then Delegate Addison had House Bill 271.
Okay. I like that we're making some improvements here. I think it's smart. I mean, we obviously understand that this is a problem statewide. I think anything we can work through the subcommittee. I know some of the bill sponsors aren't on right now. Or they are here. Okay.
Yeah, I see Delegate Naraki's here, Delegate Conway's here. I don't think Delegate Holmes was able to make it. I did chat with him a little bit earlier today, so he is aware of the hearing. The link was sent to him. I'm not certain if he's able to make it.
Sounds good. Thank you, Chair.
All right, thank you. Delegate Valentine.
Thank you, Madam Chair. I got here a little bit late where you were explaining everything. Do you already have this in print so where I can visualize this?
Yeah, it should have been sent to your email
Okay.
this morning.
Okay.
I apologize.
No, I'll double check. I'm sorry.
Okay.
I'll double check my papers.
Okay. Give me one moment, guys. I'm so sorry. I'm having a little bit of a technical situation.
I got to get to this, Madam Chair, so I know you got us on hold. Give me a section two. Motion for the favorable.
Can we move favorable? Did I miss something here?
I think we're waiting on the chair to come back.
Okay. All right. Looks like a bunch of people jumped off somehow.
I think we're waiting on the chair to come back.
Okay.
And did that amendment come from? Does anybody see?
Yeah,
Yeah,
it was attached to the
In Delegate Williams' email. Yep.
Okay.
to the notice for this meeting.
Delegate
Does
Williams,
everyone
have the
want to
amendment?
share
Do
their
you need me to
screen
resend
and
it?
then we could see it? But I mean, I
Oh, I
have
can
it.
share my screen.
I
Maybe
have it, but I'm just saying if anybody else is having trouble.
Let me see. Oh, it says sharing not turned on. Let me see if I can.
Now I got to get to. Hold on a second. I got to get to.
It was probably sent like maybe around 9:30-ish this morning. All right, I'm trying to see if I can share my, okay, there we go. Here it is.
11:12, I think.
Okay,
Let me
all
take
right,
a look.
can you see that? I'm sharing my screen. Can you guys see that there? Okay, so let me scroll to the top here. So,
Yeah, we got it.
okay, so you can see here at the top, we amended
The
to
title.
include all of the names there. the new title of the bill would be Real Property Wrongful Detainer, Time of Hearing and Service of Process, which are the changes to help to try to expedite the matter. I'll scroll down to when the amended language starts to begin, which is here on, I guess this is page 3 of the bill. And you can see here about the hearing portion
So,
that I
so you're
mentioned.
limiting when this can be used.
Go ahead, Delegate Phillips.
I'm trying to make sure, so we're limiting when this can be used, right? So if it's
No, there's
already,
anyone who believes that someone is allegedly unlawfully in possession of the property. So if you remember in Delegate Addison's bill, it limited to those who were selling the property or leasing the property. This amendment does not contain that language at all. It can be used by anyone who believes that someone is unlawfully occupying the property.
but this says this section does not apply if. And number 2 says a remedy is available under Title 8 of this article. So wait a minute, am I missing that? So there are other remedies under Title 8. So if I'm
Title 8, I
available,
believe, is the landlord-tenant article. Is that correct,
correct,
Claire?
correct. So if it's a standard wrongful detainer like a holding over, there are other provisions under Title 8 that would cover it? Or am
Yeah,
I,
so I mean, if you have yes, so those would revert back to just a normal landlord-tenant with the writ of eviction and those types of things.
so
And that's
this is,
current law. That's current law.
that's current law.
Yes,
So I want to make sure. So what we're trying to do is deal with squatters.
correct.
And so if there are other remedies for individuals that have a lease, or it's alleged that they have a landlord-tenant relationship,
Mhm.
that would fall under Title 8 of the article,
Correct.
is right? Because I know we're trying to my concern in all of this, and I don't know that we still have addressed it, are for those individuals who is so to ensure that it is not abused,
Understood.
right? So, and to ensure that people don't try to come here as a landlord, they don't try to come here and use this to get somebody out who already who is in a agreement, whether written or unwritten,
Mhm.
for the leasing of their property.
That is correct. So if there's just a regular lease, then all of that would fall under Title 8, is my understanding. And I don't know if we have them in the waiting room. I know Matt Hill with the Renters Alliance, or that I know he represents tenants in a number of instances. I'm not certain if he's on the call. Yeah, I do see Matt Hill here. That would apply in those situations. But Matt, I don't know if you have anything you want to add to that.
Thanks, Madam Chair. Yes, Matt Hill, Public Justice Center and Renters United Maryland. That's correct. So the wrongful detainer is only supposed to be used when there's not a landlord-tenant relationship. And I really appreciate the work that Madam Chair has done here and the work of the committee members, and appreciate moving away from the process in which you'd skip the court and just go straight to the sheriff. Madam Chair, may I just express one concern about the time period?
Sure.
So I'm just thinking in very concrete terms, if a trial is held 4 days after filing, and let's say the complaint is filed on a Monday, which means the trial could be held on a Friday, and you're supposed to. And I also want to say I really appreciate the addition of the good faith attempts at personal service. That's really important, and we appreciate that. But assuming that you did one good faith attempt on Tuesday, another good faith attempt on Wednesday, you could try to post the property on Thursday and mail it, the problem is that, you know, you're really just giving that person really maybe 1 day notice. And then the mail's not going to get there before, you know, you can mail it on Thursday. It's not going to get there on Friday. And there's a Supreme Court case, Green v. Lindsay, that mailing is a critical component of any sort of due process here. So it has to be nail and mail. And so I am concerned that this time frame is too aggressive to provide for constitutional due process still, even though I really do appreciate everything else that you've proposing in the bill. But I am very concerned about that. And I think the Attorney General's office, when they were looking at Delegate Addison's bill, had a similar concern about that aggressive timeline.
Okay. Well, I appreciate that feedback.
Do we,
Go ahead.
I was
Go
going to
ahead,
ask, and
Delegate
do we,
Phillips.
yep, and on this attempt, the good faith attempts to serve, do we designate who must serve?
It doesn't specify, it just says whoever is who is
By Maryland rules.
yeah, it would be by the
So-
Maryland
so-
rules. So it could be the complainant, or it could be a
It
process
could be the
server,
sheriff.
or it could be the sheriff.
Okay.
Yeah.
Okay. But the court would have to issue.
The court would have to issue
What's
the
what's-
summons. And I'm trying to make sure I'm seeing everyone because I'm sharing my screen right now. Oh, Delegate Taylor, sorry.
No worries, thank you. We were talking about in situations where there's a lease, what if the lease is illegitimate? Now, there were some examples where folks would go into a leasing arrangement, and that leasing arrangement was illegitimate. How's it handled under this new bill?
It will be handled the same way it's handled currently under the law. So this doesn't modify the way leases are done currently at all.
Even illegitimately, so the folk that you signed the lease with doesn't really own the home?
Yeah, so the
Same.
folks who signed, so this is regarding, in theory, and I don't know if Claire can assist, but this would be for the person who's in possession of the property. The property owner may have a cause of action against the other person separately, who drafted the fraudulent lease, and that would be a separate action. But this would be with regards to the person who is actually in possession of the property. Okay, and I see a couple of hands up. I don't know if it says the farm, and I'm not certain who that is, if that's Mark there.
Chairwoman, it's John Morrissey from the Judiciary.
Oh, hi, Judge Morrissey. Oh,
my
thank you.
my conference room is called the farm. The other conference room down the way is called the bay. I have pictures of animals all over. You just can't
Okay.
see. Maybe you can see behind
I
me.
do
That's
see the picture of the farmhouse there, yes.
I asked if I could change the name, but it's too complicated for me
Okay,
to
no
do
worries,
it
no worries, Your Honor. Yes, if you could elaborate, that would be great.
Couple things. Going to Delegate Phillips, the way the code is structured is that anything that involves a landlord-tenant relationship is in Title 8. Wrongful detainer is specifically not a landlord-tenant relationship, so it's in Title 14. So you guys put it in the right area. But if a situation were to come up where the person says, I have a lease with this landlord, it would protect that they wouldn't be able to proceed under this wrongful detainer statute. They'd have to go under Title 8, either failure to pay rent or breach of lease or tenant holding over or something like that. As to the situation that Delegate Taylor brought up, one of the reasons why we got involved in this bill is because I agree with public justice in the sense that we couldn't let the sheriff do this because there are individuals. There's kind of two tracks I see. There's the person that's just squatting in the property and is there illegally in possession of the property, but there's this whole group of other people that are pretending like they're the landlord and leasing it to unwitting people. And so if the unwitting person, why the court wanted to get involved, if the unwitting person is there, they'll be able to tell the court that at this hearing, and then the court can manage how that's going to work. And, maybe give, what I've done is typically say, all right, well, I'm going to have to grant possession in favor of the landlord, but I'll give you X number of days to move out so that they can get their affairs in order. That would be the normal way it would be handled.
Okay. All right. Thank you, Your Honor. And the next hand I see is Delegate Tolles.
Yes, thank you, Madam Chair. I had a question for Judge Morrissey in terms going for just elaborating on what you were just saying in reference to the time frame. Is 4 calendar days and not more than 7 days? Is that enough time with the court's docket to be able to hear these cases?
We would make it a priority, and that's what we said we can do. We're supposed to send failure to pay rent cases in that time frame. Now, whether we can do that, the volume on failure to pay rent cases is 300,000 or more a year. There wouldn't be as many of these cases, so we could make this a priority. And that was kind of I got involved in this when we weren't involved in it. So it was, I was trying to do the right thing, basically. And they asked, how quick do you think we can get this done? I vetted it through a number of my judges. We think we can do it within that. That's why 4 to 7 days, we kind of accounted for the weekends in there in case it came in on a Friday, that kind of thing.
Okay. I had some little angst about that. So,
Mr. Hill did raise a good point, though, on, I hadn't seen the amendments when I first talked about this on the mail and nail in the attempts. And he does have, I always worry about the mail because the mail's been running slower than before. And I know there's an urgency to get into court on these things, to the extent that whatever you guys decide, we'll make it a priority is what I can assure you all.
Okay.
Thank you. Madam Chair, can I just do a quick follow-up?
Yeah, sure.
Thank you. So Judge, knowing that Prince George's County is a large jurisdiction, has a heavy, traffic flow at our courthouse, do you believe Prince George's County, would also fall in that category where they can meet this timeline?
Right. I mean, I would tell, as part of the chief judge, my duties as a chief judge, I would direct my courts to make this a priority and set it in within these dates. Again, it's not the same. I would expect a couple hundred of these cases a year as opposed to 300,000 failure to pay rent cases a year. So we can put this to the top of the docket. It's impossible for me to put 300,000 cases at the top of the docket, but I can put these at the top of the docket.
Okay, thank you. Because it's a statewide bill, I wanted to ensure that I, hone in on the workload of Prince George's County.
Yeah.
And ensuring they can handle that. Thank you, Madam Chair. Thank you, Judge.
Okay, thank you. All right, next I see Delegate Phillips.
Thank you, Madam Chair. So I've got 2 questions for Judge Morrissey. One is, have we put in enough protections that landlords wouldn't attempt to use this to abuse the process? Because this is a much faster way of getting people out, particularly if we don't have a written document between parties. So that's one question. And then the second question, little concerned, are we, in the notice piece with posting two attempts, letter, certified letter, at some point you all have to determine if all of those things happened as part of your review. Are we putting too much on you, I guess is the question. So those 2 questions.
So the first question is that we already deal with that in wrongful detainer action. So we have to make a determination whether the landlord is the appropriate party that actually owns the house in right now in every wrongful detainer action, and that they're not trying to pull one over on the court, or trying to avoid the, whatever the other regular remedies are. So there's kind of a routine that you go through when you're dealing with these to make sure you're assured that you have jurisdiction over the case. And that wouldn't change on this. As to the other, again, services outside of the court, I just, what I said before was I agree with Mr. Hill in that the timing to expect a landlord to do these things in that amount of time and still get into court may be problematic. But I know the concern was that these were taking a long time when someone has zero right to possession in the property. But that's the one case, that's the squatters type of example. The other cases, somebody probably paid a $1,400 deposit in first month security, and they think they're in the property rightfully, and now their whole world's just been rocked because the landlord says, I'm the actual landlord. This person, they call it bona fide purchaser for value in the commerce world, but it's the same kind of theory where this person did nothing wrong, but yet they're going to be evicted. And that's why I thought it was important for the court to be in between it so that we could manage that process. So the person's unfortunately still going to get evicted, but we could give them time so that their stuff's not, put out on the street tomorrow.
Okay. Okay.
Okay.
Thank you. Next I see Delegate Pastor.
Yes, thank you. I think this has already been addressed, but a constituent actually called in to say that 4 days doesn't provide enough time from getting the notice of eviction to trial, and that the mail takes too long where they are. So I wanted to just share that since one of my folks called in.
Okay.
Thank you.
Thank you. Okay. Mr. Hill, I see you have your hand up.
Thank you, Madam Chair. I just want to address Delegate Phil's question as well. And I agree with Chief Judge Morrissey, and we don't always agree, so I want to acknowledge Chief Judge Morrissey and I agreeing. It's a good day.
It is a good day.
So, but this is to Delegate Phil's question, because I think there's a third category of folks who are caught up in these situations, and that is legitimate tenants with a predatory landlord who is attempting to bypass landlord-tenant law and use wrongful detainer. And there was an article just recently in the Baltimore Banner about one of our clients who was in the exact same situation. We've heard testimony that there are survivors of domestic violence who are caught up in a situation where their abuser owns the property and attempting to evict them through wrongful detainer. Probably should not be. Those folks all have defenses. But again, if they don't have service of the complaint in time to get legal counsel, in time to get off work, in time to get to court, then they're not going to be able to make all those defenses, right? And so that's been our priority concern from the beginning. We suggest at least 14 days from service to trial. You could have a hearing within, say, 18 days from filing to trial, and service at least 14 days prior to trial. We think that's a much more reasonable timeline that still balances, the need for the property owner to have their rights adjudicated and the need for tenants to have notice and constitutional due process. Thanks.
I'm sorry, Matt. Can you, I just want to make sure I understand. So you're advocating for the hearing to take place 14 days after service, or 14 days after the complaint has been filed?
So service, I think you could set up a system where you could say something like, trials should be held no later than 18 days after filing. And then alternative service, but in all situations, the alternative service, meaning the nail and mail, should take place at least 14 days prior to trial. Just some guarantee that there's some time for the tenant to get legal assistance if they have a defense and prepare the defense.
And Mr. Hill, you struck that third one that I was thinking about as well, so thank you.
Yeah, I hear what you're saying, Mr. Hill. I guess that, so now we're talking about an additional 2 weeks that that person who is the lawful property owner has to still wait to even get a court order. And I understand you're trying to strike the balance with the person who's occupying the property. I'm just worried about the 14 days just being a little bit too long. Anyway, Delegate Schmidt, I see you have your hand up.
Thank you, Chair. And I think I would have to agree with you there. That is a really long time for a lawful owner. This is not a typical landlord-tenant situation. I mean, perhaps we could look at 4 business days instead of 4 calendar days, maybe something of that nature. But I mean, this is in alignment with the current filing. And to piggyback on what Delegate Pasteur was saying, this is not an eviction. So I know that constituents are reaching out regarding eviction. This is separate from an eviction.
Right.
Okay. Because my worry about the doing it 14 days after the date of service. So here's the thing, because the court has to, and Judge Borsey can totally correct me if I'm wrong. I'm thinking from a court administrative standpoint, they have to put some type of date on the summons. And so there has to be some type of finite period in which a hearing has to occur. And I feel like the homeowner or whoever's in possession of the property needs to know when that date is. So
I think currently when you file, I believe, and maybe Judge Morrissey could correct me, when you file,
you get a hearing date.
yes,
on the
but you
summons
file
right then and
prior,
there.
if you file prior to Wednesday, you get a hearing the following Wednesday, if I'm not mistaken. And the timelines may be a little bit different in jurisdiction, but I know in Baltimore City, I believe if you file by Wednesday, you have a hearing the following Wednesday. That's 7 days. And somebody may be able to help me with that. It's closer to it, but I mean, that's typical in Baltimore City, I know.
Yeah. I mean, so I guess my question for Mr. Hill, would you be more agreeable to say, okay, the hearing has to take place, I get the summons, I attempt 2 days, I post and mail out on that 3rd day, saying the hearing has to take place within 14 days after the complaint is filed?
So if it was 14 days after filing and then we do have this in Baltimore City, there's a provision that service has to be completed within a certain number of days after filing. So in other words, completing service within 3 days after filing. And so again, just creating some sort of provision to make sure that tenants are going to have, because again, it could be a squatting situation. It could also be a predatory property owner trying to abuse the process. So having something that said, I'm going to say like 16 days from filing and service shall be complete within 3 days of filing, or something to that effect would also work, I think, to meet both bounds.
What is complete service?
So as I understand it, under this bill, the amendment, it would be 2 good faith attempts at personal service and then posting and mailing. So it's
all of those would have to be done for service to be complete.
That's what the bill says. Yes, and right now the bill would say that all that has to be done, and the trial takes place on the 4th to 7th day after. So.
I can come back to you, Delegate Phillips. I see you're thinking.
Yeah, I'm thinking.
Okay.
Yeah.
All right, Mr. Pipkin, I see you have your hand up. We haven't heard from you today.
Hi, good afternoon, everybody. Matt Pipkin with the Maryland Multi-Housing Association. Hold on 1 sec, sorry, my camera's going weird. I just want to also throw out there, first off, these are terrific amendments. Really do appreciate the body being so deliberate about this. I just want to flag for everybody, there is an appeals process in the bill as well. So, I mean, if there really is an issue that pops up, and I mean, there are ways to counteract that. And look, I mean, as far as Mr. Hill's concerns about predatory landlords using this wrongly, I'm more than happy to add something in this if there's some sort of bad faith attempts. I mean, I'm more than happy I'll be the first one to say that we need to address any predatory landlords misusing this. I think the way that we've written this, though, I mean, this will really curtail what is a small but a very important issue that has just arisen in this state. So I'll leave it at that.
Delegate Naraki, I see you have your hand up. Thanks for joining us.
Thank you, Madam Chair. I appreciate it. I wasn't sure your rules, if you would let me say a word. So thank you, Madam Chair, for that. Certainly appreciate Mr. Hill's concerns. I sit on the Housing and Real Property Subcommittee in ENT, so come at these issues often from a different perspective, but I'm very familiar with these landlord-tenant issues. My concern with making, that I think Mr. Hill said 16 days. I'll just give one example. And I've had hundreds since I filed my bill, people contact me. One of which was a constituent of mine, senior citizen, came home from a nursing facility where she was rehabbing her knee, and someone was in her kitchen making breakfast. So this lady had nowhere to go in her kitchen. So if we're gonna wait 16 days, that poor old lady is still gonna have nowhere to go for 16 days. I think this time frame is much more reasonable. I would also add that right now we're debating. In fact, it's on our agenda for tonight in HRP, Housing and Real Property. We're debating a reclamation time period. I'm concerned that may also kind of get mixed into this, a reclamation time period for how long someone has to get their possessions. That's 10 days, right? So if that were to somehow apply to this, 16 days plus 10 days, we're at 26 days there at that point. We're almost at a full month. That's a long time for someone to not be in their property. So I think this is a much more reasonable time frame here that the committee has suggested through these amendments. And thank you, Madam Chair, for allowing me to voice that.
Sure, absolutely. Delegate Conway.
Thank you, Chair. I just wanted to be clear on the record, is squatting and wrongful detainer a single subject, or are they
basically the same thing?
Basically, or are you saying they're the same?
I mean, if you're wrongfully detaining someone's property, then that could be seen as also squatting. Squatting is kind of a colloquial term. Legally, that you're wrongfully detaining someone's property.
If you're squatting,
you're wrongful possession of someone's property.
Okay, thank you.
Mr. Hill.
Thank you, Madam Chair. Just briefly, so to address Delegate Nowaki's point, the whole reclamation period of property does not apply in actions under 14.132 under the bill that's being proposed. So that's not going to be an issue in this particular kind of case. I hear what folks are saying on the committee. Is there any way to consider just a trial within 2 weeks of filing and service of the complaint within 7 days of filing? To me, that's 2 weeks for someone to be able to and then really just 7 days to be able to seek legal counsel and try to mount a defense, because the appeal period is important. But if you don't know the actions even taking place, you're not going to be able to appeal it in time.
Yeah, I hear what you're saying, Mr. Hill, and I think service is important. I definitely want to make sure we're not running afoul constitutionally of someone receiving service in due process, which is why the amendments that were proposed. I guess in my mind, maybe I want to kind of split the baby some and maybe propose 4 days in terms of service, and then have the hearing scheduled, say, within 10 to 14 days. I don't know if that would work. And I don't know if Judge Morsi is still here, if that's something he thinks would be feasible for the courts.
Thank you, Chair. To be better than what it is right now, I kind of agree with Mr. Hill on the dates, but I would defer to you all on it. It's better. It at least gives a reasonable period of time to get everything accomplished from a notice perspective.
Okay. Okay, I see Delegate Conway, then Delegate Taylor, then Delegate Schmidt. I was going to give you a piece of paper. Delegate Taylor? I'm sorry. Delegate Conway, were you talking? Nope.
No question.
No. Okay, no problem. Delegate Taylor.
Thank you, Madam Chair. Did we ever flesh out whether business days would be the better way to handle it? Are hearings held on weekends? I just don't know.
No, they're not held on weekends.
Okay.
I would have a big fiscal note on that one if they were.
Yeah. So does it make more sense to say business days, just to make sure that 14th day or whatever that?
Well, I think 14 business days would stretch that out to more like 21 actual calendar days. You
Yeah.
have to factor in the weekend.
I
And if
agree.
there's a holiday or something like
Okay,
that.
all
Yeah,
right.
the general rule in the judiciary, if it's less than 7 days, it's by business day, but if it's more than that, it's just regular calendar days.
Yeah.
Perfect. Okay, and then does wrongful detainer include timing? Like so for instance, in my neighborhood, there was a house that it was a squatter's house at first. That guy moved out, but the realtor apparently used the house for parties. Didn't own it, but it was used. What would is something like that included here? Are we just talking about somebody moving in and living there without permission?
I, was that to delegate to Mr. Hill?
I
Delegate?
don't know. Whoever can answer, or if it's
think it's something
not
totally different.
applicable, then say
Something-
that too. But
They would be violation of code of ethics, honestly.
Yeah.
That would be something totally separate.
Yeah, I think so.
I
And
agree,
so
it would be
there-
separate.
Yeah, there's a flavor of this too, where a property is like in a pending foreclosure and that the owners of the property have vacated the property
yeah,
and the bank comes in prior to equitable, prior to them having full title and they maybe put a lock on. I'm not saying that's right or wrong, but I know that this happens. They'll put a lock on it. And then if anyone else breaks in, I guess that could go under, a criminal violation at that point. But there's not a good answer to that, Delegate.
well,
Okay.
appreciate you trying.
All right. I know we're gonna have to wrap this up here soon. Delegate Schmidt, I see your hand up, and then I think,
Yes, Chair, I would just like to circle back. I mean, if we did 4 business days and 7, or 4 business and 10, I mean, that makes it workable. I mean, even Judge Morrissey said he would make this a priority and it's a small amount. I mean, the idea is to get the rightful owner back in their property. I mean, the last thing we want is grandma not having a place to live.
right, absolutely. So service in 4 business days, and then the hearing within 14 calendar days after the complaint is filed. Is that what you're proposing?
I said 10 business days.
Which
10
comes out to
business
14.
days, which
Okay.
could be as many as
Long time.
15 days, I
Yeah,
think.
yeah, that's a long
Okay.
time.
It'd be 14 Saturday, Sunday, and you got 10 business days, 5 and 5.
You could have another Saturday, Sunday in between if you're talking about
Yeah,
Friday.
that's true. So you want to tighten that up a little bit. That's true.
Yeah, yeah, 'cause
7 business days brings you into 9, maybe even
Yeah, 7
11.
business
Yep.
days.
So
Okay.
7 business days.
All right. So now I'm
Business
having
days.
issues. Okay. So
Yeah.
why don't we do this, guys? Why don't everyone take a look at this? We'll try to figure out a time tomorrow to meet to finalize this. And then take it from there. But I think we're on a good track right now.
I mean, paragraph 2 would be the only paragraph to correct. I mean, you can see it here on the screen. Hearing scheduled under subparagraph of this paragraph should not be held less than 4. You would strike calendar, put business, and then you would have in not more than 7 business days. I mean,
Right.
that paragraph kind of wraps it up.
Okay. Okay.
Just the thought.
Claire, do you think you might be able to work up something that kind of reflects what we're discussing? And then maybe we can do one more final review tomorrow?
So just to clarify, all that's gonna be changed is the words calendar in paragraph in the new language on the first page, or
Yes, I guess that'd be 4 business days.
Yeah, not less than 4 business days and not more than 7 business days. So we just, yeah,
okay,
yes.
and that's it?
But I think we want to make sure the hearing. No, that's for the hearing. That's not for the
So I think we're saying that service has to be completed within 4 days,
right.
and for 4 days, and that the hearing is to be set within 7 business days.
Right.
So what happens if somebody doesn't achieve service within 4 days? The whole thing has to start over?
Well, they would have the ability to still post and mail. So they would still have, within that 4 days, they would have the 2 good faith attempts at personal service. And then after those 2 good faith attempts on 2 separate days, they can post and mail. And so then that posting and mailing would be deemed good service.
Okay, so this hearing is scheduled between 4 and 7 business days. If the service is effectuated within 4 business days?
No, I think what we're saying, Claire, is the service must be effectuated within 4 days. So the posting, the 2 attempts, and the mail. Is that correct? And then
I think that's
within
right.
7 business days would be the hearing.
Yeah, the mailing piece is already covered in the next 3 paragraphs, so I don't think we really need to address those items, but I'll lean on counsel for that.
I'm just wondering how to word this. We've got the service stuff. And then do we just add something that says this all must be done within 7 business days? I'm just trying to understand your concept. So I
think you just simply amend paragraph 2. I mean, I don't think everything else pretty much falls in line with the crux of the bill after.
Well, paragraph 2 is about the hearing. It's not about the service.
Right.
So the hearing would have to take place within, what are we saying, 7 business days after the complaint has been.
7 to 14.
May I, Madam Chair? Or?
Go ahead, Matt.
Thank you. What I heard earlier from a couple different people was that you would change the current numbers for, and my understanding, Chief Judge Morris, you can correct me, but normally when we get over 7 days, we're talking about calendar days, and when it's 7 days or under, it's considered business days. That's what I think the rule is.
Yeah.
So I'm sorry. And so I would suggest you could do the hearing shall be held not less than 10 calendar days, not more than 14 calendar days. And then in a separate paragraph, you'd have, I believe you suggested, Madam Chair, service within 4 days of filing. That would, I think, address a lot of the concerns and be a little more workable. And give time from the service to trial period.
Okay, I'm so sorry. Does that make sense, Claire?
So basically, 10, the first paragraph of new language, change it to 10 calendar day, not less than 10 calendar days, and not more than 14.
No, that doesn't make sense. No, hold up. No, I think the hearing has to be held, I guess, not less than 14 days. Let's just say no less than 14 days after the complaint is filed.
14 calendar days?
Yes. And then, yes.
But the
yes.
hearing's called off if service is not effectuated within 4 days of filing.
I don't know if service would be, if the complaint would be called off, but it would be services determined as of the date of trial, because people walk into court all the time, even though they've not been served.
Right.
And the other way, we haven't talked about this, but this kind of, I don't see the sheriffs being willing to go out and make 2 separate attempts on this and then file an affidavit with the court. This would be by private process server. And if the process server can catch the person, they'll serve them personally.
Right.
So even if the person is not served properly under these provisions, if they hear about it somehow and show up in court, then the hearing still goes forward.
At least the MREM portion of it for the removal from the property, but it wouldn't be for money damages at that point.
Right. And nothing
So
about
there's,
this is for
yeah,
money
there's two
damage,
different things.
so.
I won't, there's two different principles of jurisdiction, in rem or in personam. And in rem means the property. And in landlord tenant, you're trying to remove the person from the property. If you want money damages to go along with that, there has to be personal service. There can't be any of this mailing and nailing and that kind of thing.
Right.
And the bill envisions that.
I see a bunch of hands.
I'm just
I'm
trying
sorry,
to
go ahead,
figure
Carol.
out how to word this. Service must be effectuated within 4 business days. Do I just add a new subsection that says that?
Maybe.
Maybe that's a question for Judge Marcy. Anywhere else do we give a time period for which service must be effectuated?
I don't know the answer to that, Delegate. I honestly don't.
I don't think we do. All right, I have a whole bunch of hands. I see Delegate Schmidt, Delegate Tolles.
Do
Thank
you
you,
want to
Chair.
hold it, Madam Chair? Because we, or
Yeah,
you
I
want to
think we
keep
can,
it
I think we
on?
could try to figure out a time to meet
I
tomorrow.
mean, we've done some good work here today. I mean, it's just about buttoning up some of the timelines. You know, I
Yeah,
don't want to go, we have, 5 bills that we're putting into one, and the sponsors obviously have a lot here. So I think we're on the right path. We just got to button up some of these timelines, I think.
okay, that, I would agree with that. Delegate Phillips.
Yeah, I will say one thing, Madam Chair. I do think it's important, if we're saying that this is kind of an urgent scenario, that I do believe we should put some onus on the petitioner with a timeline for which service should be effectuated.
Okay,
Because otherwise, I think we should put some impetus on the petitioner.
okay. I see Delegate Naraki shaking his head yes. Did you want to add something?
Yes, Madam Chair, I would agree with Delegate Phillips. I think these are often urgent scenarios. I've literally talked to
Yeah.
hundreds of folks, and in almost every one of these circumstances, they are very urgent scenarios. So I think Delegate Phillips is right to put some onus to try in any way we can to sort of expedite this process. Of course, following what the Constitution and all the laws say to give due process and things like that.
Okay. All right. And Delegate Tolles and Delegate Schmidt, I see you still have your hand up.
Yeah, I mean, I was just going to say that the kind of latest discussion we had around the timeline, I think we're going back to that 14 days, and I'm not sure that's the direction we were looking to go in. So I just wanted
14
to-
days for the hearing?
No, okay, I was saying for number 2, the scheduling. Did someone say 14 days for the calendar days?
No, I don't think we can do
Or
14
no, someone
calendar
said
days.
10 days, and I thought we were trying to get away from
Yeah,
that.
I don't
but-
think we can do 10.
Yeah.
Well, we can do 10 calendar days. We just can't do 10 business days based on other, just kind of other
Okay.
places in the law, and kind of generally we only do business days when the time frame is less than 10. I believe
Yeah,
that's
so
what
I
Judge
was,
Marcy said.
I kind of got, it was a lot that was being said, so kind of lost whether it was 7 calendar, 7 business, but I just wanted to say if we're we're looking to draft something for next time, I didn't want to get into down that path, and we may change it again, so.
Okay.
Thank you.
Sounds good. Thank
Yeah,
you.
I just want to remind everybody back to the beginning, we took the sheriff and the law enforcement kind of out of this. We're relying on the courts, and that's where we don't want to burden too much. So, I mean, it's about expediting the process and doing it the right and legal way.
Okay. All right, we're gonna find a time tomorrow. I know it's a little crazy because we're getting closer and closer to crossover. We're gonna find a time. I don't think we'll need more than 30 minutes to just finalize this, but I think we're on a good track right now. So, continue to mull it over the next maybe 24 hours. And I will try to figure out what time tomorrow works. Your Honor, I know your schedule's super crazy. I think, so I think we have a bunch of stuff in the morning. So it might have to be in the afternoon. If you are able to join us, we completely understand, but I don't know if you have time in your schedule tomorrow afternoon or not.
Depending on the time, Delegate, I'm in St. Mary's County tomorrow, but I can take it from the car. I don't need to be on video, or I can make myself available down there.
Okay, okay, that sounds great. That sounds great. Especially because it seems like we have procedural questions, so we want to make sure whatever we're moving forward with that works for the judiciary and your processes. So, okay, all right. Well, this has been great, guys. I think this has been a really good conversation, a really good discussion. Thank you guys so much for everything. I know Civil is about to meet right now. So for those on the Civil Law Subcommittee, I will see you guys there. And for everyone else, take care and stay tuned for a time when we will meet tomorrow.